Welcome back to the Verdict Room. I'm your host, and today we're diving into a world most of us don't fully understand, but desperately need to. A world where criminals don't need guns, don't need to enter your home, and don't need to look you in the eye. A world where a single keystroke can expose millions of lives, steal billions of dollars, and potentially paralyze critical infrastructure that keeps our nation running. We're talking about cybercrime, and in 2026, it's no longer a theoretical threat. It's happening right now in courtrooms across America, and the cases we're about to examine reveal just how vulnerable every single one of us really is. Let's start with something that shocked the entire intelligence community. In December 2020, a Russian-backed hacking group infiltrated one of the most trusted software companies in America. SolarWinds, based in Austin, Texas, creates network management tools used by thousands of organizations, including the U.S. Treasury Department, the Department of Homeland Security, and countless Fortune 500 companies. Nobody noticed the breach for months. The attackers had hidden malicious code inside a legitimate software update. When customers downloaded the update, thinking they were protecting their systems, they were actually installing a backdoor, a Trojan horse. By the time the breach was discovered, an estimated 18,000 organizations had been compromised. And here's what makes this legally fascinating. Prosecuting cyber criminals is extraordinarily difficult. Why? Because they're often working from foreign countries with governments that won't extradite them. The US Department of Justice did manage to identify 6 Russian GRU military intelligence officers involved in the SolarWinds attack. In October 2020, they were indicted for espionage and computer fraud. But here's the reality: those officers have never set foot in a US courtroom. They likely never will. The indictment serves as a public record, a statement of facts the government believes it can prove, but without custody, without extradition, the prosecution cannot proceed. So why bring the charges at all? Because it sends a message. It puts names and faces and specific conduct on the public record. It constrains those officers' movement internationally. And it signals to allies that the US is tracking these crimes. But from a justice standpoint, from the perspective of victims seeking recompense or closure, the SolarWinds case illustrates a fundamental problem in modern cybercrime prosecution. The rules of criminal procedure assume criminals can be brought into court. When they can't, the entire legal system struggles. Now let's move to a case where we actually got someone in the courtroom. In May 2021, the Colonial Pipeline Company, which supplies nearly half the gasoline and diesel fuel to the East Coast, was hit with a ransomware attack. Ransomware is a specific type of malicious software that encrypts a victim's data, making it inaccessible, and the attacker demands payment, ransom, to decrypt it. Colonial Pipeline paid approximately $4.4 million in Bitcoin to regain access to their systems. But here's where it gets legally interesting. The FBI managed to trace and recover much of that Bitcoin. In June 2021, a person named Brandon Martin of Baltimore, Maryland, was arrested and charged with conspiracy and money laundering related to facilitating the ransomware payments. Martin was accused of running a darknet marketplace and helping criminals move proceeds from cybercrime. But the actual hacker group behind the Colonial Pipeline attack, the group calling itself DarkSide, has never been prosecuted in US courts. The FBI attributes them to Russian cybercriminals, possibly with state-level support. They've essentially disappeared from public view since the Colonial attack, likely due to diplomatic pressure from the US government. So again, we see a pattern. The actual perpetrators remain outside US jurisdiction. Those who get prosecuted are often the money launderers, the facilitators, the people who help move the stolen money through the financial system. That's a critical legal point. When you can't reach the primary offender, prosecutors pivot. They charge everyone in the conspiracy chain. Everyone who knowingly participated in the scheme, everyone who facilitated it, everyone who benefited from it. Now let's shift gears to a case that genuinely shocked the financial world and resulted in an actual trial with an actual verdict. In November 2022, FTX, one of the world's largest cryptocurrency exchanges, collapsed in spectacular fashion. We're talking billions of dollars vanished. The founder and CEO, Sam Bankman-Fried, who was 30 years old at the time of the collapse, had become a celebrity in the crypto world. He donated millions to political campaigns. He was on magazine covers. He appeared in Super Bowl commercials, and it was all built on what prosecutors would later describe as one of the most significant financial frauds in American history. In January 2023, Bankman-Fried was arrested in the Bahamas, where he'd been living in a multi-million-dollar penthouse, and extradited to New York to face federal charges. The indictment alleged wire fraud, securities fraud, money laundering, and conspiracy. The core allegation: Bankman-Fried had secretly moved billions of dollars of customer funds from FTX to a trading firm he controlled called Alameda Research. He then used that money to make risky investments, to bail out his allies, and to purchase real estate and yachts. When FTX started to collapse in November 2022, the scheme unraveled. Customers who thought their money was safe in the exchange discovered it was gone. The trial began in November 2023 in federal court in Manhattan. Prosecutors presented evidence of text messages, emails, and testimony from insiders showing Bankman-Fried had knowingly and intentionally moved customer funds without authorization. The defense argued that Bankman-Fried believed he was following proper procedures, that he was young and made mistakes but didn't have criminal intent. That word, intent, is crucial in white-collar crime prosecution. Criminal intent, or mens rea in legal terms, means the defendant acted knowingly and with purpose. It's not enough to say someone made a bad business decision. Prosecutors must prove they acted with guilty knowledge. On November 8, 2023, after just 8 hours of jury deliberation, the jury returned guilty verdicts on all 7 counts. Sam Bankman-Fried was convicted of wire fraud on customers, conspiracy, conspiracy to commit securities fraud, and conspiracy to commit money laundering. In November 2024, he was sentenced to 25 years in federal prison. The sentencing was significant because it sent a message. In 2026, the courts are taking cybercrime and digital financial fraud seriously. The fact that you can commit a crime using computers and the internet doesn't make it any less serious than traditional white-collar crime. A jury of 12 ordinary Americans looked at the evidence and said, "We understand what you did. We found you guilty." But here's what's critical about the FTX case from a legal perspective. It was solvable. Bankman-Fried was a U.S. citizen in a U.S. jurisdiction. The evidence was digital but accessible. The witnesses were cooperative. The paper trail, or rather the digital trail, was clear. This is not typical of cybercrime cases. Most cybercrime cases are far messier. Most cybercriminals operate internationally. Most evidence is fragmented across servers in different countries. Most perpetrators never see the inside of a courtroom. So let's talk about the legal framework prosecutors are actually working with in 2026. The primary federal statute for computer crimes is the Computer Fraud and Abuse Act, enacted way back in 1986. Yes, 1986. This law predates the internet as most people know it. The CFAA makes it illegal to intentionally access a computer without authorization, to obtain information by fraud, to cause damage to protected computers, and to traffic in passwords or access devices. But here's the problem. The CFAA was written before cloud computing, before mobile devices proliferated, before artificial intelligence, before the internet became integrated into literally every aspect of American life. Prosecutors and defense attorneys argue constantly about what the statute actually covers. Then there's the Computer Fraud and Abuse Act's companion statute, the Wiretap Act, which governs the interception of electronic communications, and the Electronic Communications Privacy Act, passed in 1986, which also predates modern technology. These laws have been stretched, reinterpreted, and expanded by courts trying to apply decades-old statutes to crimes that the original drafters could never have imagined. There's also the wire fraud statute, used extensively in cases like FTX, which makes it illegal to use interstate or foreign communications to execute a scheme to defraud. That statute is actually quite effective because it's technology agnostic. It doesn't matter if you send a fraudulent email or a fraudulent telegram. If you use interstate communications to defraud someone, it's wire fraud. But prosecuting cybercrime faces a fundamental challenge: attribution. How do you prove who actually committed the crime when the perpetrator is hiding behind layers of encryption, VPNs, darknet marketplaces, and cryptocurrency? Law enforcement has gotten better at this. The FBI has dedicated cyber divisions. The Department of Homeland Security has cybersecurity specialists. The Secret Service investigates financial cybercrimes. But the bad guys are also getting better. They're using more sophisticated encryption. They're operating through peer-to-peer networks. They're laundering money through multiple cryptocurrency transactions. The arms race is real. What's also changed in 2026 is the role of civil litigation alongside criminal prosecution. When a data breach happens, like the kind that exposed millions of Americans' personal information, the victims often file class action lawsuits seeking damages. The company or entity that was breached becomes liable, even if they weren't the criminals. Companies like Equifax, which suffered a massive data breach in 2017 that exposed the personal information of 147 million people, ended up paying a settlement of $700 million to affected consumers. That settlement was a civil remedy. It didn't require proving criminal intent. It only required showing negligence, that the company failed to protect data it was responsible for protecting. This is important legally because it creates two avenues for justice: criminal prosecution of the actual hacker and civil liability for the entity that failed to protect the data. Sometimes you get both. Sometimes you only get one. But the law is evolving to recognize that cybercrime victims deserve compensation, and companies have a legal duty to implement reasonable security measures. We've seen this reflected in new state laws. California passed the CCPA, the California Consumer Privacy Act, back in 2020. New York passed the SHIELD Act. These laws create legal obligations for businesses to protect consumer data and to notify consumers when breaches occur. If you fail to do so, you face civil and potentially criminal penalties. But here's what keeps cybersecurity experts up at night in 2026: the emergence of AI-assisted cybercrime. Artificial intelligence can be used to craft more convincing phishing emails. It can be used to identify vulnerabilities in networks faster. It can be used to automate attacks on a massive scale. We haven't yet seen a major trial where AI-generated attacks are at issue, but we will. The question is, how do you prosecute crimes powered by artificial intelligence? If an AI system committed the actual intrusion or fraud, who bears criminal responsibility? The person who programmed the AI? The person who deployed it? Both? The law hasn't caught up with the technology yet. So what does all this mean for you? What does it mean for the average person watching this video in 2026? It means this: your data is valuable. Your information is targeted. Your devices are potential entry points for criminals who may be thousands of miles away. Your best defense is not the legal system. The legal system is slow, and it often fails to reach the actual criminals. Your best defense is basic cybersecurity hygiene. Use strong, unique passwords for every account. Enable two-factor authentication. Don't click on suspicious links. Keep your software updated. Use a reputable antivirus program. And understand that if you become a victim of cybercrime, the legal remedies may be limited. You can report it to the FBI, to local law enforcement, to the FTC. You might be able to sue in civil court, but you might never see the person who stole from you prosecuted, simply because they're operating from a country that won't cooperate with US law enforcement. The cases we've examined today, SolarWinds, Colonial Pipeline, FTX, they represent different facets of the cybercrime crisis. SolarWinds shows how nation-states can conduct espionage through cyber attacks. Colonial Pipeline shows how criminals can extort critical infrastructure. FTX shows how fraud can hide behind digital architecture and technology jargon. And all three cases reveal a legal system struggling to keep pace with crimes that outrun statutes written decades ago. In 2026, we're at an inflection point. Congress is debating updates to the Computer Fraud and Abuse Act. States are passing new cybersecurity laws. The Justice Department has doubled down on prosecutions, even when international cooperation is limited. But the fundamental problem remains: cybercriminals are often beyond US jurisdiction, and the technology enables crime at a scale and speed that the legal system can barely comprehend, let alone prosecute. So here's my question for you. How should the law evolve to address cybercrime in an era where attackers operate globally, anonymously, and with technological sophistication that outpaces law enforcement? Should we expand federal authority to conduct cyber operations against foreign attackers? Should we increase penalties for companies that fail to implement basic security measures? Should we create international treaties that force countries to cooperate in prosecuting cybercriminals? The answers aren't simple, and frankly, the law is still being written. Thank you for joining us in the verdict room. If you found this analysis valuable, please subscribe, comment below with your verdict. What should be the legal system's priority in combating cybercrime? And share this video with someone who needs to understand just how vulnerable we all really are. Because in 2026, cybersecurity isn't a tech issue. It's a legal issue. It's a national security issue. And it's personal. We'll see you next time.